Lawyers, what was the case that you would rather lose but accidentally win? Story 1. Not me, but a senior lawyer I met at a law school event. Before he went into civil litigation, he used to be a prosecutor. He told me of a case where an accused was facing charges of harm. He was the prosecutor responsible for handling the file. He was convinced of the accused's guilt and had substantial evidence pointing in the accused's direction. The senior lawyer fought hard to secure a conviction, but the accused had excellent counsel who created doubt and identified defects in the evidence. The accused was acquitted. The senior lawyer was pissed. Many years later, however, new evidence emerged, showing decisively that the accused definitely did not commit the crime, and, in fact, it was another person. The senior lawyer said that he was happy he lost the case because, if he prevailed, an innocent man could have spent years in prison. Story 2. I was appointed to do a review hearing for a guy that had been deemed a sexually violent predator. After serving 20 years in prison for 2 abduction rapes, he had been committed to a state hospital under the sexually violent predator statute. He got an annual review to see if he should continue to be held, which is what I was handling. I fundamentally disagree with this law, but am glad I lost that one. All of the discovery materials from his old cases were provided to me. Raped one woman while holding her boyfriend at gunpoint and shot the second one when she fought back. He was a suspect in a half-dozen more where he wasn't prosecuted. Dude is a flat-out serial rapist, and it wouldn't surprise me if there were some harmed women in his wake as well. I hope he never gets out. Story 3. I presented a domestic violence case for civil protection order for a parent who had custody of 2 kids. Got lots of evidence of defendant showing up and screaming at my client, past history of abuse, corroborating testimony from family members of my client. The night before trial, our client finally gives us 2+ years of Instagram, phone, and Facebook messaging. Our client and defendant's new partner taunt each other, sending photos as defendant goes back and forth between them. Defendant is focused only on getting visitation with the children, repeatedly asks to see them, sets up a date, and my client misses the handoff and taunts defendant. Defendant shows up to court and will clearly be amazing on the stand. My client is not. We negotiated a settlement that included specific visitation and helped our client finally begin divorce proceedings, which would, as part of them, have a judge make a determination on the best interest of the children, which would be way more shared visitation than these two could work out between themselves. Our client wanted to use the court to avoid sharing custody out of spite, but what our client and the children needed was stability, not more drama. Story 4. I used to work for a law firm specializing in subrogation cases on behalf of insurance companies. Basically, if you file an insurance claim for something that wasn't your fault, your insurance company will pay you, but then go after the person whose fault it was to recover their money. My lowest point as a lawyer involved a customer who made a claim for a car accident. The accident happened because a dog ran out into the street and the car didn't have enough time to stop. Unfortunately, the dog was killed in the impact. There was also some damage to the car, which the insurance company paid to the car owner, but it turned out there was an ordinance in the accident location requiring dogs to be on a leash in public areas at all times. Meaning, technically the dog owner was at fault in the accident. So my job was to write a demand letter to the owner of the dog who just died, demanding that he pay for the damage that was caused to the car during the accident that killed his dog. The dog owner never responded, and luckily the insurance company decided it wasn't worth additional legal fees of pursuing it further. It just about killed me to write that letter. Luckily I don't work there anymore, and haven't done any subrogation work since. Story 5. I've wanted to be a trial lawyer as long as I could remember. To be frank, it's one of the only jobs I could actually do, and be happy about it. My 2 favorite things to do are argue with people and solve puzzles. Being a public defender allows me to use my talents for the benefit of others, and keeps the adrenaline rush I get from a good argument flowing constantly. I realize I'm basically an adrenaline junkie in a business suit, so I really wanted to be able to help people. Public defender clients are always poor, often homeless, often mentally ill, and often chemically dependent. They are people that need help. They are folks that have been ignored or marginalized their entire life, and just need someone to stand the FCK up for them. I love doing it, and I also love being the underdog. Do you have any idea how fun it is to kick the government's ass when you aren't supposed to? I also have a bit of an anarchist streak in me. Not a teenage-style Lowell Molotov cocktails FCK government type of anarchy, but a basic belief that, whenever possible, the government should leave people alone, and that it is possible a lot more than the government says it is, especially when it comes to criminal justice. I stand opposed to the government in every court hearing I attend, so I enjoy being able to call the government out on their bullshit. The pay is low for a lawyer and will never be high for a lawyer, but my wife and I are both public defenders. We make about $130,000 gross between us. That's enough to live far more comfortably than our clients. As for the high stress, totally accurate. The job can be very stressful, and self-care is important. If you don't get some enjoyment out of it, you won't last long. I'm basically a petulant toddler, with a good speaking voice, a bigger vocabulary, and a nice suit. That's my job, and I dig it. Story 6. Week to week it varies. A fair average would be 50 or so. Some weeks it is much more, and you might see me in the office on a weekend, but other weeks it might be less, if a judge is on vacation, and there isn't a ton of court or something. My day-to-day work is made up of reviewing files, making contact with clients, and appearing in court. Those are the biggest aspects of my job. Reviewing files is necessary to be prepared for court, and so is trying to keep in touch with my clients. Then, I go to court and do whatever needs doing there. There is a lot of improvising in public defense, and a lot of split-second decisions that have to be made on a daily basis. I have to trust myself to be able to navigate through those situations, because second-guessing yourself can cripple your case and your client. Daily work is fast-paced, often changing, and keeps you on your toes. My office policy is to attempt to limit us to court 4 days a week, so we get at least one office day. Mine is usually Friday, which is perfect. Work-life balance is a constant struggle. It's made more complicated in my case because my wife is also a public defender, and our days/weeks don't necessarily mirror one another. For example, my wife might have a very difficult day in court, while I have a very easy one, or vice versa. So at the end of the day, figuring out where we both are mentally is the first goal. Despite our careers, my wife and I are somewhat introverted, and love the comfort of our home. Often a nice warm cup of tea and a good book is all the stress relief either of us needs. Both of us make a conscious effort to take one day each weekend specifically to not work. No checking emails, no returning phone calls, no picking up the work laptop, and no glancing at files. Usually we choose Sunday for that, because we like to watch football together, so Sunday is just a natural day. We keep to that fairly well and call each other out if we slip up. You need a day away from this job. We also get very generous sick time, which accrues at the same rate but separately from vacation time, and can use it once a month for a mental health day. So typically my wife and I will take a long weekend once a month. Just to decompress. It's definitely worth it. I never struggle with a case based on how nasty or grotesque it is. The allegations in murder and rape cases don't bother me. I can't let that be my focus. I have a very important job to do, and a client counting on my advice. They need me in fighting shape, not questioning the humanity of their actions. I figure that can be everyone else's job. My job is to be their voice, their advocate, and stick up for them when the rest of the world won't. I do dwell on cases, more than I probably should. Some losses hurt more than others. I tend not to dwell on the wins, except to share with my coworkers. We have a poop emoji pillow that we pass around the office, with a sign that says, "You're the shit," that sits in the office of whoever has the most recent big win of some kind. I try to learn something from the losses, though. Despite my beliefs going into trial, after the trial, the truth is, There are some cases nobody can win, and if I see that after the trial, there is no harm to my client. But if I approach a trial with that mindset, then how could my client ever stand a chance? So I analyze my losses and try to see whether there was something I could have done more effectively, or whether it was just a bad set of facts. Usually it is the latter. Public defenders, if you ever meet one, have a sick sense of humor. So sick I won't even repeat things we say on Reddit or anywhere in public. Our office is a safe space, so to speak, to say whatever we want. That's how we deal with the crazy nature of what we do. My office could make a sailor blush, and most offices are the same way. I think I hit everything. Do you have any more questions about what it's like? It's Sunday, so I'm not working. My wife won't kill me if I talk about work, though. Story 7. Courtrooms are rarely cinematic. Most trials drag like bad soap operas. Endless procedure, papers shuffled, bored jurors trying not to yawn. But every once in a while, something happens that feels like a scene straight out of a legal drama. This particular story, shared by a Redditor recalling the legendary trial lawyer Jerry Spence, is one of those moments. The case itself was simple. A man was suing the city, claiming he'd been injured in a bus accident. His big argument? He could no longer lift his arm properly. Pain, reduced mobility, lasting damage, all the boxes ticked. The jury listened politely, the kind of politeness reserved for church sermons and DMV lines. Then Spence stood up. No grand theatrics, no monologue about truth and justice. He just asked the witness, "Sir, could you please show the jury how high you can lift your arm now, after the accident?" The witness complied. He made a pained face and gave a feeble demonstration, raising the arm barely halfway. The courtroom atmosphere was sympathetic. Here was the poor victim, visibly suffering. Spence didn't argue, didn't press. He just tilted his head and said, "And could you please show the jury how high you could lift your arm before the accident?" That was it. A simple follow-up question. And the witness, God bless him, instantly raised the arm high over his head in a perfectly fluid motion. For a split second, the entire courtroom froze. The man had just demonstrated that the arm was fine, the injury imaginary, the lawsuit essentially dead. The jury burst out laughing. Spence didn't need to say another word. The case was over in that instant. This is the kind of accidental win every lawyer dreams of. No need to hammer legal precedent, no elaborate cross-examination. The witness himself had proven Spence's case. In fact, if you think about it, Spence hadn't even done anything special. He just let the man walk right into his own trap. Now imagine being the opposing lawyer in that courtroom. You prepare your witness, coach him, build your whole case around his testimony. And then, in front of 12 people who now think your client is a liar, he destroys it with one careless gesture. At that moment, you probably want the ground to swallow you. You'd rather lose slowly and with dignity than be humiliated in 30 seconds by your own witness's arm. And here's the delicious irony. Spence wasn't trying to humiliate anyone. He just asked 2 calm questions. The win practically fell into his lap. Story 8. Another lawyer on Reddit described a case that was both depressing and darkly hilarious. It involved domestic violence, a landlord with questionable ethics, and a lawyer who didn't even need to open his mouth. The situation: a woman had been brutally beaten by her husband. On top of her trauma, the landlord tried to evict her. His argument? That the incident had violated the lease agreement. Essentially, that she was responsible for the disturbance caused by being beaten senseless. It was a heartless, cynical move. The woman's lawyer came prepared to fight, but before he could say anything, the landlord's counsel, perhaps trying to sound tough, perhaps simply not thinking, launched into his opening statement. And in that statement, he did something remarkable. He carefully laid out, in detail, exactly how badly the woman had been beaten. He described the incident, the police response, the level of violence. Everything the defense would have needed to prove. The judge listened. The opposing lawyer finished his monologue. Then the judge turned to the woman's lawyer and asked, "Do you have anything to add?" The lawyer simply replied, "No, Your Honor. I believe opposing counsel has already said everything that needs to be said." And that was it. The case was effectively won right there. The landlord's own lawyer had just proved the defense's position. No cross-examination, no arguments, no frantic scrambling for evidence. The win was handed over on a silver platter. It's one of those rare cases where victory feels almost uncomfortable. Yes, you win, but you win because the other side was reckless, because the injustice was so blatant that even their own lawyer couldn't spin it. It's not a satisfying battle. It's watching your opponent punch himself in the face until he falls over. Story 9. An ex-boss of mine has spent over 7 years litigating a relatively small case, about $300,000 in total liability. The defendants refused to settle, and their lawyer was totally inept and possibly mentally ill, filing all kinds of voluminous, 1,000-plus pages, and totally frivolous motions. He appealed every magistrate ruling to the district judge, and then tried to appeal every district judge ruling to the Federal Court of Appeals. He was even sanctioned for his conduct, which he of course appealed to the Court of Appeals. The punchline is that this was a case for unpaid wages and overtime under the FLSA, Fair Labor Standards Act, and state labor law, which provided that defendants have to pay plaintiffs' attorney's fees. So the defendants were not only getting clocked by their attorney for all of these motions, appeals, etc., but also my ex-boss was accounting for all the time he had to spend on it. Case goes to trial. Plaintiffs win about $300,000 in damages and a whopping $600,000 in attorney's fees. Defendants appeal the jury verdict and lose. Then separately appeal the fee determination and lose. Then they refuse to pay the judgment. We bring a post-judgment proceeding to overturn obvious fraudulent transfers they made after the trial, giving away their houses and other property to friends and family, etc. Midway through this procedure, they file for bankruptcy. The whole thing is just a mess for everyone. My ex-boss is basically financially ruined by this case. Still waiting for, now $800,000 plus, in attorney's fees he's probably never going to get to collect. The defendants were financially ruined by their crazy attorney, who clocked them over $300,000 in fees while ruining their lives. Their friends and family members have been drawn into the litigation over the fraudulent transfers, and they may well end up facing jail time due to fraudulent statements on their bankruptcy filings. The plaintiffs are still waiting on wages they should have been paid almost 10 years ago. Oh, and I got laid off because my ex-boss couldn't afford to pay me anymore after all of this. So yeah, all in all, maybe it would have been better if he'd lost the case years ago. Story 10. Not a lawyer, but when I was a paralegal, my boss got a sex offender acquitted of the most serious charge of first-degree sexual assault. We had a confession he'd given to our firm's hired shrink locked in my boss's desk drawer. During the trial, the lawyer had me, at the time a woman in my 20s, sit directly beside the perv so the jury could see I wasn't afraid of him. He insisted on taking the stand. During his testimony, I casually turned around to look at his wife. On her face was etched a look of horror. She, who knew him best, could tell he was lying. Up to that point, I guess she'd believed his story, that the teenaged employee was just after his money. I felt so gross after that, and switched to a real estate and refinance law firm. Story 11. Was a labor lawyer for some time, and we had a no-exception policy against using the company credit card for personal expenses. Everyone knows you get fired for it because they beat it into you with frequent training, make you sign stuff, etc. We fired a guy who was a few months from retirement, and his union filed for arbitration. Arbitration is kind of a joke, And any labor lawyer will tell you that no arbitrator would uphold that termination even if the guy wasn't near retirement. We won. Due to the way the pension worked, the fact he left before he reached 55 led to a massive pension discount, like hundreds of thousands of dollars. Oh, by the way, his offense was filling up his car with gas, using company card, because he had left his personal card somewhere and was going to run out of gas. On the other side of the coin, I had many employees do insane things like hide and sleep at work for 40 hours, lead to a 30,000-gallon gasoline spill, fighting, death threats, etc., who all got their jobs back through arbitration. Story 12. I used to do divorces mostly. I'm not cut out for that work, but it's the job I could get out of law school. A guy came in for a divorce and seemed, by all accounts, really nice. He claimed that they had $50,000 in cash in their safe, and that his wife had taken it out when she left the house. His ex-wife never worked, so seemed reasonable she would take the money when she left. We sued for the money back and got it. A few months later, I saw him in the news. Turns out he harmed his wife and buried her under a new patio in the backyard. He made up the story about the money to make the cops think she'd run away. Story 13. This is a repost of my personal worst. I'm thankful that my work is now more fulfilling. A while back, I represented credit card companies suing for outstanding debts where we had pretty stringent client guidelines dictating how we handled lawsuits. The bottom line was that we were to be aggressive in court so as to put our client in favorable positions during any settlement negotiations. One defendant was a 40-year-old female who had maxed out all her credit cards in a futile attempt to pay for health care for her husband, who ultimately died of cancer. In total, she had spent something along the lines of $60,000 paying for chemotherapy, hospital stays, and various other bills. She ended up losing her job, husband, and home, all within the span of 3 months. She didn't even bother showing up for hearings or responding to the complaint, meaning my client won a default judgment against her. The worst part? I had to stand up and tell the judge what my client was entitled to. $60,000 for principal amount, $80,000 for interest and late fees, $10,000 in attorney's fees. She now has a judgment of $150,000 against her. I refuse to do that line of work anymore, and have made it a point to represent people against credit cards if the opportunity presents itself. Story 14. I was only a part on our trial team, meaning I just drafted pleadings but didn't do the stand-up work at trial. But there is one case that really showed me I'll never work for the man again. The case basically involved a little girl with massive disabilities. Mind of a baby, no talking, motor skills / strength of a baby, pretty much can't do anything on her own at all, who had been supposedly harmed by her caregiver. The caregiver worked for a state agency, and we were the firm that did all this agency's litigation. To make a long story short, no one at this agency knew what the FCK they were doing, and the actual caregiver had no training whatsoever in dealing with special needs children. This was in a really remote area, and they hired the caregiver at the last minute knowing she wasn't qualified. The girl's disabilities were so bad that it would honestly be hard to say whether or not she was actually harmed by the substandard care. That isn't the shitty part. The shitty part was how much money all this shit cost. The state spent nearly $100,000 modifying its facilities so the girl could get in, out easier, and use the restroom easier. We, because we had to in order to defend the case, hired all these experts on disability law, medicine, neuroscience, psychology / psychiatry, etc. I don't know if you guys know how much experts cost, but it is routine for us to pay $30,000 or so for a report and a few hours of testimony in court. This case had at least 4 experts that testified for us. So the state spent a bunch of money before the case started trying to help the girl. Then we spent a shitload of money defending the case. Oh, did I mention we had at least 6 lawyers on the case, including 2 partners? On top of this, the girl's family obviously had to hire lawyers to fight ours, so I'm sure they spent a lot of money too. Their representation was on a contingency fee, but they are still responsible for these sorts of costs, and they were poor as hell. I'm talking about scraping the bottom of the barrel poor. They were from a very remote area, lived in a shitty house, and neither parent had a job. They pretty much survived because of the government checks that paid them to be their daughter's home health aide. Nonetheless, they certainly incurred a ton of expenses, even if their lawyers were paid on contingency. Needless to say, we won at trial. It should have never gone to trial, but that is a story for another day. I didn't go to most days of the 2-week trial because I had to work, and I'm too junior to be trial counsel in federal court. I did, however, go to hear closing arguments and the verdict. When I heard the verdict, the first feeling I had was one of mild relief. It is important for the firm that we win cases that we should win, like this one. I had also spent a lot of time on it, and it's nice to know that time wasn't wasted. But that feeling of relief lasted about 10 seconds. After that, I just felt sick to my stomach. The girl's family, who are all really nice people, looked crushed. It was probably the most emotionally painful thing I've ever been a part of. I felt like I was part of a huge injustice. We had basically beaten the shit out of this family for 3 years, then spent a shitload of money to prove that our client didn't hurt their daughter. The family had spent a shitload of money too, and they got nothing for it. The state spent a shitload of money to defend the case, and the family got nothing for it. The only people who won were the lawyers and experts. It was a huge waste of money, and it was all for nothing. The family is still poor, the girl is still disabled, and the state is still providing substandard care. Nothing changed, except that a bunch of people got paid a lot of money to argue about it. Story 15. Defense attorney here. I've represented many clients in rape/sexual assault cases. I've been lucky in that every one of them, I was either confident they were not guilty, or at the least knew there was reasonable doubt, and an acquittal was the right result. There was one client, however, when I was not. It was a date rape case where the alleged victim was highly credible in my opinion, and there was some physical evidence. I didn't want my client to even talk to me, because I was afraid he would accidentally confess and limit my options if he chose to testify. Alleged victim testified and of course came off as credible. I felt my cross was pretty ineffective too, as she answered my questions truthfully. I was fully prepared for a guilty verdict, but the jury came back with a full acquittal. I guess when you consider the evidence against the government's very high burden of reasonable doubt, it makes a little sense. But this is a prime example that winning doesn't always feel great. Story 16. I had a client whose boyfriend agreed to be listed as the dad on the birth certificate, despite him knowing he was not the father of the child. At the time of the birth, he swore in affidavit he was the bio dad, and it got filed by the state. Of course, he and his girlfriend broke up shortly thereafter. A few years later, he regretted his decision and no longer wanted to pay child support for a child that wasn't his. Representing the mom, I successfully made the argument that although a non-biological father could get out of paying child support in the case of fraud perpetrated by the mother as to the paternity of the child, no such defense was available to a man who voluntarily signed a birth certificate with full knowledge that he was not the father. The law was on my side, but it seemed like a pretty hefty punishment for someone who made a stupid mistake. Story 17. I found that kind of weird, but on the other hand, his moral compass was on the fritz, and, as I later learned, he also had a substance addiction. He was 10 years away from disbarment at this point, and desperate for cash. "So what are you going to do?" I asked. "I'm not doing anything," he said, "because you're going to deal with it." "Why don't you get Demetrius to do it?" Demetrius had civil experience. I had almost none, other than the little I'd gained from fixing Demetrius's FCK UPS. Demetrius was a great rainmaker, but a terrible lawyer. His career ended the same way as Aaron's, a nasty crash and burn at a Law Society disciplinary hearing. The application's in 2 weeks, and he's got another case. Maybe. But what was more likely was that Aaron seriously needed the 50 grand, and he knew that he could not trust Demetrius to deal with it. Aaron gave me a copy of the application and told me to get it ready for hearing. I spent the next 2 weeks researching the law, drafting affidavits, and preparing the Book of Authorities. The day before the hearing, Aaron told me that I was going to argue it. I was terrified, but I did it. The judge granted the application, and the client was happy. Aaron took the 50 grand and paid me 5. I learned that day that the legal system is full of desperate people who will do anything for money, and that you can get away with a lot if you know the right people. But it's too late when you realize that the system is corrupt from the inside, and you're part of it. Story 18. I've spent the last several years working with law firms as a computer forensics expert. I've helped lawyers with a great many cases over the years, analyzing evidence for their clients on computers, phones, drives, the works, and even presenting/explaining it all as an expert witness in court. One case in particular sticks out. During a particularly contentious divorce case, out of nowhere, the wife was making allegations of physical abuse. And she was being very specific, right down to the date and time, location, everything. The husband, who was very wealthy, was also undergoing radiation and chemotherapy treatment for late-stage cancer, and from his physical condition, it was obvious to everyone, even to non-medical personnel, he couldn't win a fight with a dried leaf, let alone raise a hand to his wife, who was several inches taller, probably 20 pounds heavier, and a betting man would say she was probably stronger than him as well. We were hired by the husband's legal team to analyze his phone, computer, etc. to see if there was any evidence of abuse. There wasn't. But what we did find was evidence that the wife had been having an affair with the husband's best friend for the last 5 years. And she had been planning to divorce him for the last 2 years, but was waiting for him to die from cancer, so she could inherit everything. When he didn't die as quickly as she expected, she decided to accelerate the process by making false allegations of abuse to get him out of the house and speed up the divorce. The judge threw out the abuse allegations, and the wife ended up with nothing. But the husband died a few months later anyway. The lesson? People learn too late that false allegations can backfire spectacularly in the legal system, but by then, the damage is done. Relationships destroyed, lives ruined, and sometimes, it's fatal. Story 19. He'd never been to court as a lawyer, never, not once, at least, not for anything that had been reported. He'd worked hard inside a government ministry for 20 years for not much money, at the end of which he was rewarded with a judicial appointment. The judge was smart. He knew his law. But he had never conducted a trial, not once, in all his years at the bar. He had no knowledge of the law of evidence, and even the court rules were something of a mystery to him when he was first elevated to the bench. So the day of trial came, and I got into my car and I fought traffic all the way to the court on the worst highway in the world, leaving very early to avoid being late. I was ready for an old-school trial, with paper and live witnesses and briefs and tabs, and I brought everything. Just like in the old days, with extra copies too, in case the court staff lost the copies I'd filed for the court. The judge was late, and when he finally took the bench, he looked confused. He didn't know how to call the case, or how to swear in the witnesses, or even how to rule on objections. It was a disaster. The trial took twice as long as it should have, and in the end, the judge made a ruling that was completely wrong on the law. We appealed and won, but by then, my client had spent thousands of dollars and months of stress for nothing. People learn too late that the legal system is run by humans who make mistakes, and sometimes, those mistakes are because the judge doesn't know what they're doing. By the time you realize it, your case is over and you're left with the bill. Story 20. Except, the statute is not always read so narrowly, and it was invoked in a case where the wife, Mary, died approximately 3 weeks in a car accident after telling her husband, John, she wanted a divorce and started packing her things, and had a complaint in divorce drafted but not served to John. After she died, her sisters, only surviving family, intervened and sought to continue the divorce and distribute half the marital assets on her behalf to them. I litigated this cluster of CK for 3 weeks on John's behalf. 3 weeks, because the judge at first bought into the sisters, Rationale. I had to bring in a conflicts expert as outside counsel and write a lone rationale as to how the sisters' position violated everything from common law understanding, as well as numerous statutes. In the end, we won, but it was a mess. The sisters dragged John through hell, trying to take half his assets after his wife's death. John was devastated, not just by the loss of his wife, but by her family's greed. He learned too late that the legal system allows for posthumous divorces in some cases, and that family can turn on you when money is involved. By the time the case was over, John was bankrupt from legal fees, and the sisters walked away with nothing but hatred. The system protected him, but at what cost? Story 21. Long story short, we need the lawyers. You/Pepperoni Fire made good points about the true nature of their job. The lawyer is an expert on the law. If there is to be any discussion at all, or any difficulty, then you need an expert. There are cases in civil courts with literally thousands of contested points. Some take years. Working in building law can turn into working on one case for 2 years, that is, Monday to Thursday in court, then use the weekend to prepare for next week. No one person was responsible for all this. No one person can sort through all this. No architect or engineer is going to understand all this. They know about buildings, not contracts about buildings. And this isn't really a case of the law being complicated. It's a case of the contract being complicated, because it deals with a lot of things. If you're either litigant in that case, you need a lawyer. People learn too late that trying to navigate the legal system without a lawyer is like performing surgery on yourself. You might survive, but the scars will be permanent, and the pain unbearable. By the time you realize you need one, you've already lost half the battle.